topics that I want us to cover for today, then, please, are firstly a brief introduction and a recap over some of the core principles which apply to all of us practicing within the coroner's system, followed up by a legislation update and also a look at some of the key case law developments which took place during 2021 and the early parts of 2022. We'll then move on to considering the impact of COVID-19, and I'll give my view as a practitioner practicing within this area up and down the country nationwide. We'll also have a look at the new competencies for lawyers guidance, which has been issued to all of us practicing within the coroner's courts system. And then finally, we'll have a look at some of the funding issues, particularly those which are relevant to bereaved families attending coroner's proceedings. We'll take a look at some of the issues arising, including equality of arms. Many of us will be aware of the charity Inquest, which does some very important work on behalf of bereaved families, really highlighting the issues of importance to them. Inquest has, for a long time now, called for automatic, non-means tested public funding for legal representation at inquests of bereaved people following state-related deaths in particular. The charity has long highlighted what it calls the unfairness and the equality of arms for bereaved families. It highlights the point that whereas public and private organisations attending at inquests are almost always legally represented, public funding for families has been far more limited historically. Some families have been represented by personal injury law firms, in my experience, particularly where there is an associated claim, or by private or other means, including crowdfunding. But certainly it's long been the case that public funding has been thin on the ground for bereaved families.